Hey, and good morning. This is Gavin Wyman here, and this is the first of a series of broadcasts I hope to do. There we go, 9 o'clock. This is the first of a series of webinars or streams, not sure what to call them. It's a bit of an experiment on my part. But let me introduce myself to anybody out there. I am a lawyer by background and training, and I have been training FIDIC, NEC, JBCC, GCC contracts for the last, I suppose, 20 years now, since about 1999. I'm just looking for my cursor on multiple screens here to just close something distracting on my desktop. The idea is to deliver a 45-minute talk on a contract topic each Friday morning, and we're going to use Friday slot from 9 to 9:45 for FIDIC contracts, discussing anything that you like. You can suggest topics in the chat, and if I see an interesting topic come across being placed, if it doesn't fit into today's schedule or ideas, then we can do it in following Fridays. Looks like I'm talking to myself at the moment. If you do join, please just say hello in the chat so I can see that there are people out there. A little bit about myself. As I said, I was a lawyer by background and training. I was in private practice in Pretoria for close on 27 years. In the year 2000, I was asked to do a training course on contract management and administration, and in preparing for the course, did not find a lot of material on the internet, although the topic and subject has now become quite popular. One could in fact do a course on the contract management of FIDIC contracts. One could also do a course or session or discussion on the administration of various aspects of FIDIC contracts, like claims, communications, payment, terminations, DAB processes, and so on. But for now, today, the idea is to simply introduce myself and the FIDIC contracts, and maybe key up topics to talk on in the future. I also plan to put a meeting procedure panel on, so we could have guests sitting there with me in a meeting, and I could interview them, they could interview me, and we could see how that's going. In the meantime, I don't see anybody out there. Anyone out there? If you are, just pop in and say hi, and join the chat session on the side of the screen. So for 27 years I was in private practice. My interest was litigation, a lot of contract litigation, quite technical but interesting, and I have this sort of love of contracts. I suppose it comes also from a political view that the state should be uninvolved as much as possible in human life or human activities, so that people can arrange their own law through contracts, literally. Anyway, to come back to the topic at hand, FIDIC, let us have a look at some FIDIC contracts. Are you hearing the audio? It says I was reconnected successfully. I'm not sure what that means. Anyway, if you want to talk to me here while I set this up on a different screen, that's the one screen. The other thing I'd like to capture would be the FIDIC documentation, FIDIC contract, and this stuff can be closed. The OBS instructions can also be closed. So we will just have two things here. We will have that can be closed as well. So we'll have our PowerPoint presentation, and we will have Scrivener. So we can maybe swap between the slideshow and the contract itself. All right. This can be made smaller. All right, so let's look at what a contract is and a FIDIC contract is itself, and maybe have a little talk around the slideshow at the same time. So I'm going to move over to look at the slideshow. There we go. So the slideshow will come on live now. And let's have a look at a few slides, and let me tell you a little bit about FIDIC. First of all, I might not have mentioned that I am a South African lawyer by background and training, not an American one. And although if you do have questions relating to United States contract law, or the law of England and Wales, you're very welcome to ask for explanations in the chat, and we can add that to our discussion. So FIDIC, of course, is a French acronym. I can never say it correctly without butchering it. Fédération Internationale des Ingénieurs Conseil. I think that might also be the Portuguese pronunciation. The English, obviously, for the acronym is International Federation of Consulting Engineers. And when people talk about the suite of contracts or family of contracts provided by FIDIC to the construction industry, they often use the phrase the FIDIC rainbow. And the reason for that is fairly obvious. They have, as a marketing device, chosen to use the different colors for their different contract covers. So the red book would have a red cover, and the yellow book, for example, a yellow cover along those lines. Hence a rainbow or a kaleidoscope of colors. So back to our slide. So the FIDIC rainbow, obviously, when I talk about the second edition, I might want to say either FIDIC 2 or FIDIC second edition or FIDIC 2017. When I want to refer to the first edition, we might say FIDIC first edition or FIDIC 1999. And then if we want to talk about the various variations or the palette of contracts that they provide, we might say the red book, the yellow book, the silver book, the green book, or whichever book or contract form we are addressing. And by contract form, I assume that everybody knows they mean a standard template of document found in a book called the General Conditions, together with any other documents that people may use to put a contract together. And we'll talk about how one puts a FIDIC contract together in a moment. So this is an introduction to their rainbow. You can see on the picture on the side over here the different colored covers. That is the green book over here. This green book contract is used This green book contract over here is used Sorry, I just never know if this thing is stuck or lagging. I'll have to watch the recording a bit later to see how it works. The green book is used, as you will see a little later, for smaller or less complex works, and we will look at the use case for the different forms. You'll see there's also a gold book. So let's move past this first slide and have a look at the organization itself. There's the French acronym for FIDIC, obviously headquartered in Geneva. That's perhaps why it's French. The organization was actually started by a group of Benelux countries back prior to the Second World War. That got a bit of impetus after the war ended, and the organization has grown after that essentially from strength to strength. The website you can find over there. It's actually very useful to visit their website. They often have lots of resources, slideshows they've done. They have a bookstore where you can buy the books online, and many other features. It might actually be worth one day having a look at their website and doing a reaction talk to it, so one can learn a bit more about what's available there. Next we can look at the founding date, 1913, as I said, just before the Second World War, just towards the end of the First World War, I guess. And after the Second World War ended, they expanded their reach to 40 national associations. Now, national associations are voluntary associations of consulting engineers in a specific country or for a specific country. Of course, because they're voluntary organizations, there's nothing to say that a country can't have more than one of them, but usually one of them then predominates and might be then viewed as the national association. In South Africa, our National Association for Consulting Engineers is called CESA. That's the acronym, CESA, for Consulting Engineers South Africa, and their head office is in Bryanston in Johannesburg. The FIDIC organization published first conditions of contract. Conditions of contract are the general conditions of contract, which are amended by a set of special or particular conditions to hack, fine-tune it, or tweak it. In other words, to create a customized version of the template. So the template is normally called the general conditions of contract. The document that customizes it or makes it, shapes it for a specific project, so it becomes sort of semi-bespoke, sometimes called the particular or special conditions. And collectively, the two documents read together are called the conditions of contract. So the first conditions of contract, or general conditions with suggestions on how to fix it, was published by FIDIC in 1957. This was close to, I suppose, 60 years ago. And that document was based on a UK building contract or construction contract, rather a construction contract, not a building contract. This was the UK, United Kingdom's ICE, Institution of Civil Engineers, General Conditions of Contract, 4th edition, which was published in 1945. The net result was that after FIDIC had adapted this particular form for use by their consulting engineers around the world, the document had quite a strong civil engineering flavor to it. And in fact, that civil engineering flavor can still be found in the current red books, whether they are the first or second edition, with definitions like site, which is reminiscent of some sort of civil engineering site, a piece of land upon which a civil engineering works has to be done. And when this then needs to be adapted to other kind of engineering, like electrical engineering, for example, they would have a slight extension to the meaning of site to the place or places where the work is to be done. So in this particular way, you would find you can adapt a civil engineering form to other kinds of engineering but you must not allow yourself to be misled. You need to look a little bit deeper there. So in 2004, there are 64 member associations. Remember that there are close on 150 countries in South Africa. So just over a third of the countries have associations for consulting engineers who are members of the FIDIC organization, which I suppose you could think of as the international plenary body where all the local consulting engineering bodies get together. FIDIC has has international committees to improve contracts. So one of the benefits of the FIDIC contract is that the drafting committee is represented by lawyers from common law countries, civil law countries, customary law countries, I suppose, although I have not seen a profile of the drafting committee members to see exactly what countries they come from. But I am aware that British lawyers, so British common law views would be expressed in the drafting committee. Then you would have, I know there are lawyers from France and Germany, so these civil law, Roman-based legal systems. Civil law countries really are a codified law, but it's the codified Roman law essentially that has been put into the commercial codes. So one of the benefits of FIDIC then is that the contract is drafted in such a way that it may be understood fairly similarly in countries whether they have a common law legal system or a civil law legal system. We'll have a look at some legal systems perhaps a little later. The different types of contracts provided by FIDIC, they're standard forms. Remember, a standard form is a template. The idea is if you provide a template with fairly generic but useful terms and conditions, it would prevent you or rescue you from having to draft the contract from the very first word. You can take the existing text and decide what text you might want to alter or where you might want to insert additional text, but you don't have to draft the thing from scratch. So these are standard forms or templates provided for the industry. Another benefit of this is standardization. So we will all work from a core set of terms and conditions. And the other benefit is that the tweaks and changes and amendments and additions are all summarized in a separate document. So you only really need to read the particular conditions to see how that specific instance of a FIDIC contract has been altered and customized for a specific project. Of course, contractors would be quite cynical at this particular point in time. They might suggest that the tweaks are always done by the employer to favor the employer and his contractual risk situation. I'm just going to say hello on the chat again. If you can see the chat, please say hello. All right. So to continue, so you can see there on the standard forms, I've listed the second suite, which has the red book, yellow book, and silver book. There's also now a green book, and they are bringing out new books as we speak. There are then other contracts, the short form green book, the pink book, which is the World Bank's edition or version of the red book. There is a gold book used where the contractor designs, builds, and then operates the facility on a commission to pay back the private sector funding he has provided, and manages the contract often for 20 years. It could be gold book, a greenfields development project. It could be, I believe there's a new platinum book, or at least talk of one, where they will use what's called a brownfields or refurbishment type project using a design build and design upgrade fix, refurbish, and then operate contract. The contract between the client and the engineer who is managing the contract as one of the role players would use the white book, the engineering consulting contract. They call it the client contract consultant model services agreement, client consultant model services agreement. And for the consultant to subcontract out work to subconsultants, there is a subconsultancy agreement. The joint venture agreement, you may think is a joint venture of contractors, but it is not. It is a joint venture of consultants who collectively would work together on the design and the administration of projects on behalf of a client in the contract. To take the matter a little further, we have the use case for the various forms of contract. So the use case for the FIDIC Red Book is listed here. Now, interestingly enough, this is a stolen slide. It comes out of a FIDIC presentation. And the reason I did this was to highlight that sometimes even the people who author and own the contract say things which could mislead or indicate that they don't have a full appreciation of their own contract. But let me show you this in a moment. So if you look at this particular slide, you can see that the Red Book, pictured in the right-hand top corner there, has got a much more lengthy name. It is called, and here you almost have to take a deep breath, the Conditions of Contract for Construction for Building and Engineering Works designed by the employer, and then in brackets a shorter name, the Construction Contract. Now, sometimes this is even shortened further to simply CONS, C-O-N-S, Construction Contract. Now, the first bullet there indicates the use case of the contract. The contract is intended for use where the party, called the employer, now the employer could also be the client of the contractor, although traditionally the client is referred to as the employer, the person who hires the contractor. Just a word of warning here, employer does not indicate that this is a contract of employer and employee. In other words, the kind of contract that the Human Resources Department deals with. That is a contract for the provision of services, or in Latin, plecatio conductio operarum, the letting and hiring of services. The contract we're talking about here is a species of contract for the letting and hiring of a service, or where the contractor undertakes as an independent contractor to provide the outcome, the results of a project. So the letting and hiring of a service, or in Latin, plecatio conductio operis, singular in other words. So the employer / client does most of the design work, or the employer provides the design. The contractor builds the building according to that design. Now, the Red Book does not make this a contract where the employer exclusively provides the design and the contractor cannot design anything. There are contracts to some extent like that. For example, a South African building contract called the JBCC Principal Building Agreement has the following text. It says the contractor shall not be responsible for the design of the works except for his and his subcontractors' temporary works. Now, I suppose in FIDIC that would also be clear that the contractor might have to design his temporary works, but he may also be required to design something else, perhaps a plinth upon which he's going to deliver some facility. And then obviously the wording in FIDIC is that the contractor is responsible for that part of the design that the specification says he is to design. However, this does not turn this into a yellow book. This remains a red book where in principle it is intended that only incidental design work or smaller elements of design are done by the contractor. The large overwhelming majority of the design is provided to the contractor by the employer. So in brackets you see the employer or engineer. In other words, the employer he may not be a designer, he may subcontract out that work. He may go out on tender before he starts whatever he's doing to have a beauty competition between architects or engineers, and then select a design that he appreciates. And then obviously that engineer or architect may then be appointed as his agent to administer the contract, and the contractor will build the building according to the designs given to him. So it's almost like baking a cake using a recipe without having to create the recipe as well. Now, the role of the engineer is set out in the second bullet there. So in essence, we've got a very short description of the role of the employer in the first bullet. The engineer, who is a consultant, has a separate contract with the employer, and he's an agent or a mandatory, and his duty would be to fulfill a role as a representative or an agent to act on behalf of the employer to do contract administration for him. Some of these contract administrative functions would be to give various forms of notices. A very critical one would be a notice fixing a date for the timing of the contract, the so-called commencement date. This is a very important date that must be fixed by notice by the engineer, because the completion date is calculated as a duration calculated from that commencement date, and the delay damages clause kicks in if the contractor does not complete by the end of that period, the construction period, as some people might want to call it. He also then will give various other kinds of notices, instructions. He has the power to do variation orders. He will give a taking over certificate when the work is complete for all practical purposes. And then at the end of a maintenance or defects notification period, he will issue a final performance certificate indicating that the project has come to its commercial end. And after that, the common law and latent defects would apply, although it's not unknown that some people would add additional clauses in to provide for a latent defects period. So this is essentially the role of the engineer. He's also very important for a quality control guy or person. He is the quality control first line of defense. He will observe, monitor, as they say there, the construction work, and he will issue certificates or instructions if work is defective or needs remediation, and he will monitor the administration and the repairing or fixing of defective work. And the payments are done here in what are called interim payment certificates. He will sign these certificates as certificates of payment. These, of course, are liquid documents, a very important document for a contractor, because if the contractor does not get paid, he can normally action those certificates as liquid documents in very specific type of court procedures created for liquid claims. Now, the next bullet sets out an employer's role again, which is quite interesting, and this is the bullet in which I said FIDIC is a little bit misleading. Of course, it's an advanced topic that I'm going to be introducing here to some extent, and so I'm going to maybe finish with this since there's no one on screen, and no one else participating in this webinar or stream. So let me just address this particular issue. This bullet says, employer kept fully informed, makes variations, etc. Now, first half of that until the comma is not controversial in any way. The whole idea of a consultant acting on behalf of a client is that he has a duty under the law, under the contract specific provisions, but if those specific provisions aren't there, under the common law's implied provisions, he has a duty to report to his client. So he needs to keep his client fait of all matters that can impact on his mandate or his agency. So he has a duty to report. He's not allowed to even keep secret profits. He may not even fail to report material matters without being in breach of contract. So that's all fine and well, and that's implied by the client and the consultant, the engineer, in the client consulting contracting contract, the white book as they call it. So the next thing that is interesting is that the employer makes variations. Now, to some extent, that may in fact be so. The consultant may foresee a problem. He may have a discussion with his client. The client says, what could we do? I think we should change the contract by doing a slight variation. So the client might say, I think that's a great idea, go ahead. So he may be involved in the decision, and the client and the consultant may consult with his client before doing a variation, but it's not necessarily that the consultant has to do that. The consultant obviously might, if there's good reasons for taking his client into account, but if his client disagrees and he thinks it is a correct thing to do, and the work of the safety of the project or the building might be compromised if this variation is not done, my understanding of FIDIC is that the client has to do what his consultant recommends, provided it is reasonable and rational, and the client cannot not consent, under common law ideas at least. Of course, the wording of the contract to the contrary. If the wording of the consulting contract is he may not act without the consent of his client, then the normal common law relationship between a consultant and the client has been altered by the express agreement or wording of the parties' agreement. But if we now look at the FIDIC contract, and here I'm going to show you some of the wording in the red book, which is not different or in the yellow or silver book. We're going to see here, let's look at the first edition, because it's much easier for me to find. And we're looking at the clause that deals with variations, which is this clause here. And you see the wording is very specific. Variations may be initiated by the engineer at any time prior to taking over of the works. So variations are not done by the employer. That is incorrect. Variations are done by the engineer. He initiates them in a number of ways. He can initiate it by giving an instruction. I instruct you to build the wall an extra meter higher, for example. Or another way he could initiate it is kindly submit a proposal for building the wall an extra meter higher. The next clause obviously is a change of subject almost. It says the contractor is required to carry out this variation, and it seems to suggest some circumstances where that may not be true, and this is another very controversial topic to consider in FIDIC, and we could perhaps do a whole course on this clause, or a whole Friday morning talk on this particular clause. So what can and so it talks about he must do it, and then the third topic in this clause sort of ring fences or gives an idea of what the powers of variation by a engineer are. He can't just do anything he likes. He's constrained. He's got some boundaries around what he's authorized to do, and most of these do not permit him to do brand new additional works. So what we're looking at here in essence is changes to what is there, not introducing new stuff or new work that is not there. All these variations are changes to quantities of things that are already included in the contract. So if there are plugs included in rooms, you can change the quantity of plugs in each room from 2 plugs to 4 plugs, for example. And the same applies mostly out here. And the procedure goes on further. But now, how does this help us understand why the employer can't make variations, except for the fact that this says they're initiated by the engineer? Well, if we come to the role of the engineer, his authority as set out in this particular clause, this says that the engineer may exercise the authority given to him, attributed to him by the contract, which is what clause 13 does. It attributes to the engineer the authority to initiate variations by instructions or proposal requests. It does not give that authority to the employer. Now, that sounds like a lawyer splitting hairs. Well, not really, because if we examine this clause a little bit further, you will see that it makes it very clear that the parties have agreed that the engineer does not require the employer to approve this decision of his. If the engineer decides that a variation is necessary for safety purposes, for the structural quality of the building, or for some other sensible, logical reason, he has the power to do that, even if his client does not agree, unless the parties have agreed differently. So if the engineer is required to obtain his client's approval, consent is another idea for approval, permission, his employer must agree before exercising an authority. For example, an authority to write a payment certificate, the authority to issue a variation instruction. You need to state that in the particular conditions. Remember, the particular conditions is the document that, read with the general conditions, forms the conditions of contract, the actual contract, in other words. So if you want to make it so, if you want to provide for the employer to consent to any variation the engineer must do, you would have to, in the particular conditions, write a clause something like this. Particular condition X, the third clause of clause 3.1, engineers' duties and authorities, is amended by adding the following text at the end of the second sentence. Provided, however, that the engineer shall be required to obtain the employer's consent before executing a variation that has a value of over $20,000. So that would then require him to obtain consent and certain permissions, and you will have stated that in the particular conditions. Now, again, once the contract is signed with particular conditions and general conditions, and there's now an amendment done to the consulting contract that further constrains or requires more permissions and approvals by the consultant before going out on his own to do these actions, then this last sentence deals with that. The employer undertakes not to impose further constraints unless the contractor agrees to this. This means that any further amendments to the consulting contract that impose constraints on the actions of the consultant can only be done with the approval of the employer, with the agreement of the contractor. And it doesn't say that this agreement must be provided for in writing, but I would strongly suggest that you would put that in writing, because you would need that writing to prove you have not breached this clause if you are the employer or the engineer. If you have breached this clause, or you've breached the sentence above it, it could be argued that you have fraudulently acted behind the back of the contract. and this is also a breach of contract. Quite a significant issue. So although this slide kind of deals with this in a very sort of off-the-hand way, the employer makes variations, etc., as if this is a lighter topic. This is not, in fact, a light topic. This is quite a serious topic. And let's, in a few seconds, just finish off the rest of the slide, and then we will stop for the morning. The session lasts from 9 to 9:45. It's a 45-minute session. We're a minute over time, as it were, at the moment. So payments then are done either on a bill of quantities basis, and your monthly payment certificates will be the work measured against the bill, with the rates for the bill applied for the work that forms part of that monthly interim payment certificate. Or it could be a lump sum contract, and a lump sum contract would normally break the work down into tasks or activities, a sort of work breakdown structure approach. It could be a single activity or a group of activities, like the activity foundations could consist of a group of activities like dig, place the reinforced bar, test the concrete, pour the concrete, dry the concrete, and that task or that activity, some people call it a project milestone, could have a price attached to it for pay-as-you-go type of approaches. And obviously for approved work done, this means that the engineer certifies, he approves the work of the contractor, certifies it. The contractor is not going to get paid for defective work, in other words. And that will conclude our conversation for today. Let me just say cheers, and if there was anybody out there, perhaps you want to send me an email, gavin@access.co.za. There we go. Another email I'll give you is gavin.wyman@icloud.com. You can contact me on either of these addresses for suggested topics, or if you'd like to participate as a guest in a future discussion, maybe you and I can discuss, debate, or you can question me or interview me or on a topic going forward. That might be fun as well. But for now, I'm going to sign off, and I'm going to stop the stream and the recording. Have a great morning further, and thank you for